Good evening, everyone. Thank you very much for coming to this evening, whether you're joining in person, as many of you are, or remotely, as I can see quite a few of you are also doing. My name is Grainne Mellon. I'm a barrister here at Garden Fort, and I'll be chairing the event. This is the last in our Refugee Week events of lectures, and it's on criminalising cross-channel crossings, rescue, penalties, and refugee convention compliance. The event is being live streamed and recorded, and the recording will be uploaded to our YouTube channel with the link and the slides sent to all of you. So you can relax, you don't have to take copious notes unless you want to. And after the discussion ends, of course, you're really welcome to join us downstairs for some food and some drink, and we will be thinking of you, everyone who's online and can't join us for that. Tonight, we're talking about, as I've said, criminalisation, both of migrants who are seeking asylum and also of those working with migrants and refugees. Following the draconian measures which have been passed and or may be about to be passed here in the UK, which among other things include clampdown on small boat crossings from France, we are going to explore this evening how cross-channel crossings have become criminalised in the UK and in Fortress Europe. Focusing on both Greek and the UK context, we're going to look not only at those who are seeking sanctuary and how they have become criminalised, but also how those who are committed to rescuing and helping migrants left to drown at sea are also facing the might of the state. So we have a brilliant lineup of speakers who I'm going to introduce to you now and who you should be able to see either in front of you or on the screen. Our first speaker is Seán Binder. Seán was a volunteer search and rescue worker in Lesvos and Greece when he was charged with a number of serious criminal offences, including facilitation of illegal entry, money laundering, and membership of a criminal organisation. Charges of espionage against Seán and a number of co-defenders were dropped in January of this year on the grounds of vagueness, but are awaiting a further Supreme Court appeal in Greece. If found guilty of these offences, Seán and his co-defendants face up to 20 years in prison. The prosecution has been pending now for nearly 6 years, and Seán spent over 100 days in pre-trial detention in Greece. Human Rights Watch has called his prosecution criminalisation of saving lives, and the UN Special Rapporteur of Human Rights Defender has called it politically motivated and wrong. Since his release in 2018, following his period in pre-trial detention, Seán has launched a charity called Free Humanitarians, and he has engaged in substantial advocacy and research across the EU on the criminalisation of humanitarian actors and has campaigned for human rights in Europe. He is currently, I think still, the NYU legal fellow at Justice, and he's my client. I've been working with him since September 2021. So we're really delighted to have Seán here this evening. And he's joining us from Germany, I think, but you should be able to see him behind us. He's waving just right on cue. We're also joined by Natasha Dailiani, who's the coordinator and head of legal team at the Legal Centre in Lesvos. Natasha is a Greek lawyer based in Athens. She's been working at the Legal Centre since 2016, providing legal aid and representation to migrants and refugees in all areas of their asylum claim, including family reunification, criminal administrative procedures, and litigation, including to international bodies. Speaking also in particular from the UK perspective is two of our own barristers. To my right, Jennifer Twite, who is a barrister in our public and criminal law teams. She is a specialist in youth justice and children's rights, formerly head of strategic litigation at Just for Kids Law, and she was involved in a recent challenge in the Court of Appeal on the criminalisation of those coming across in small boats, the Mohammed case from this year. So we look forward to hearing from Jen on that in particular. And last but very much not least, Georgina Ray, who is a barrister in our public and immigration law teams in particular. And she has broad experience of representing migrants day in, day out in England and Wales, and is also going to be speaking about developments in the UK. So I hope you'll agree that it's a brilliant lineup. Please do ask questions. We're going to try to take them at the end in a formal Q&A session. And if you're joining us online, please do feel free to ask a question in the Q&A box. But before we begin, we have another guest surprise special speaker, and we felt we couldn't proceed today without acknowledging the Rwanda judgment, which is a landmark judgment, a huge success, a huge relief to everyone who's working in the field, and the result of just a Herculean effort from so many lawyers, some of you here or joining us, and also Sonali, who acted and who has acted certainly relentlessly over the last year. So we're going to pass to Sonali.
Well, thank you very much for that introduction. It's just sort of serendipitous that we had an event booked, that it's Refugee Week, or part 2 of our Refugee Week seminars. The judgment came out today, and I just wanted to sort of share some thoughts about it and what it means. So important for that we had an honest and brave majority judgment from the Court of Appeal, from the most senior court we could have in the Court of Appeal, Lord Chief Justice Master Rolls, and the Vice President of the Civil Division. So it's a real vindication in terms of the legal arguments we put forward. And the arguments that were successful in the Court of Appeal are the same arguments that we've been advancing since the interim relief stage, which was actually, well, the final interim relief hearing was on the 14th of June, and it was sort of very sort of symbolic for us that we got the judgment from the Court of Appeal in the Master Rolls Court, Court 71, which was where we were at 10 o'clock at night on the 14th of June, 30 minutes before the flight was due to leave. Still 6 people on board who were shackled to the plane. Let's not forget the horror of what the individuals went through. All of those individuals had their decisions quashed by the divisional court, but they came so close to being removed and were treated so brutally in the process of removal. But I think it's really important that whatever happens finally in the judgment, and I'll tell you a little bit about that in the few minutes we've got, just remember the individuals. They are at the heart of the work that we do and why we do what we do. The Court of Appeal judgment delivered by the Lord Chief Justice. It is almost swan song because he's retiring shortly. That's Lord Chief Justice Burnett. He says the central issue in the appeal was whether the asylum system in Rwanda was capable of delivering reliable outcomes, i.e. whether it was safe in the Refugee Convention and Article 3 terms to send people to have their claims determined there. And the short conclusion of the court was that it is not safe because of the processes that the Rwandan government have in place, and because in particular the reliance on the UNHCR evidence and the other country evidence about how claims are operated there and how they're processed there. And you may well have seen some press releases already been issued by the Rwandan government. They probably invited people to go on holiday there as much as anything else, but trying to say it's safe, it's not an unsafe place, and the court have got it wrong. The report if you look at the judgment, it's something 545 paragraphs. A significant amount of that judgment is devoted to a careful analysis of the evidence they had. And the arguments were put in detail as to why, step by step, the processes in Rwanda were not safe and reliable for the asylum seekers who we had from a variety of countries: Syria, Iraq, Iran, Vietnam, Sudan, and Albania. So there's a broad spectrum of persons there, and the court was very clear in the majority judgments. There are 3 judgments, you have to read them all. It'll take a while, obviously, to digest them. But they concluded in the majority that those processes were not safe. The minority judgment from the Lord Chief Justice adopted the divisional court's view that the assurances that had been agreed between the UK government and the Rwandan government were sufficient to address the otherwise shortcomings of that process. And no doubt that will form the basis of any appeal from the government. They've already announced that they're going to appeal. And in terms of the timetable, the court indicated today they want submissions on permission to appeal from anyone who doesn't include me for these at the moment, to advance their submissions by next Thursday, so 7 days. And my imagining is that the court may grant permission itself to the Supreme Court, although that is an unusual course. That's just my own speculation. The court didn't accept that persons who were going to be sent to Rwanda by virtue of being in Rwanda would necessarily face an Article 3 risk, but that doesn't mean by virtue of conditions But that doesn't mean that individuals couldn't potentially make up that claim. It would depend on your individual circumstances, and bear in mind that waves of people never got into this processing system under the considered in this judgment. We know that victims of trafficking were not considered. We know that LGBTQI were not considered because, on the face of it, the evidence looks very suspect for that group. The other important point, I mean, it's hugely important that what the court has said is that as things stand, that the High Court decision that Rwanda is a safe third country is reversed, and that until the deficiencies in the asylum processes are corrected, that removal of asylum seekers to Rwanda will be unlawful. That is so important because the government had already said, although you never know whether it's necessarily going to be relied upon, that they wouldn't remove people until the final conclusion of the domestic proceedings. But now there's a court judgment that prevents that, as long as in the current circumstances, unless or until the evidential position changes. And it would have to change quite significantly, and it would have to be evaluated certainly by UNHCR, and then there'd have to be another court hearing. Let's hope one that's not quite as tense and stressful as the hearing that was in June, or the hearings, I should say, that were in June last year. We don't know how soon the cases will come to the Supreme Court. Let's assume they will, but potentially they could come as soon as October. And that's, again, just feeding my surmises. Although I did call the date of the judgment when I said I think we're going to get a judgment by the end of June, early July. There it was. The other thing it's important to recognise is what was refused permission, or sorry, what the court, not refused permission, but the unsuccessful grounds of appeal. And the critical one, which does sort of feed into what Jen in particular may be talking about today, is that the court found that it wasn't a breach of Article 31 of the Refugee Convention necessarily, or in principle, to remove persons seeking asylum to a safe third country. So that's, I would almost certainly imagine, is a ground of appeal that the appellants who are arguing that will want to take to the Supreme Court. It's a difficult argument about whether it is actually a penalty, and it's a different point from the criminal penalty that we will hear about a bit later on. There's the complex argument about the retained EU arguments in relation to safe third country. There's a more interesting legal argument about designation of Rwanda as a safe third country, whether it needed to be done on a statutory basis. There's a data protection argument, again, about what happens in the terms of the process of removal. And the final argument, which they say was dismissed, but if you read the judgment carefully, it doesn't look like it was really dismissed, was the asylum aid argument, which is about fairness of procedures. And in fact, the court said that their claim was rejected, but on the other hand, they did say, but on the UK government will have to amend their policies in terms of notice given, in terms of demonstrating flexibility within the 7-day notice period and so on. So it looks on the face of it like they've given some very helpful guidance to people who are actually on the grounds list as caseworkers about what you can ask for and what is reasonable in terms of representing individuals, and they didn't uphold some of the more extreme comments by the Divisional Court on that issue. So the very short sort of presentation on my part, just to give you a sort of flavour of where we're going. But the most important thing was that the policy as currently framed, or the policy was framed that the court looked at, which was the way the UK government policy as it was, and in the relevant decisions of June 2022, the court has found that that policy is unlawful. So we will see where the case goes. We'll see what changes the government makes. But for now, it is a little bit of a huge sigh of relief, and it is good news for those representing asylum seekers from this platform. So thank you very much. I don't think we've really got time for any questions, and also I don't want to hijack this event, which is actually really important, and you need to ask questions about that, but thank you very much.
Thank you very much, Sonali, and I know we'll all want to record our thanks and congratulations to all of the lawyers who've been working on Rwanda cases over the last year, and no doubt to clients, many of whom will have been worried and following the judgment as well. So back to Greece now, and to criminalisation, and we're going to start with Seán, who I've already introduced. And Seán, is going to speak about his own ongoing prosecution and also his wider observations about the EU context, both from his own academic and of course his personal experience. So Seán, whenever you're ready.
Thank you very much, Grainne. Can I confirm that you can hear me?
Yes, we can.
Perfect, thank you. Hi, everyone. I'll speak about the migration situation in Greece. I think this is useful because the UK has looked favorably on Greece's migration policies, referring to it as the Greek model. And I hope to foreshadow the potential consequences of adopting this model. Reviewing these policies is also useful for another related reason, because it brings into sharp relief the two lenses through which the so-called migration crisis is often viewed. That is either a humanitarian issue or that it is a securitization issue. Or put another way, is the primary goal offering assistance to people in danger, or is the primary goal to break up the business model of smugglers and criminals? Next slide, please. I would say that over time, the emphasis of Greek and indeed European migration policies has shifted to one of securitization. And the consequence of this is quite clear. If you are a hammer, then everything looks like a nail. And if you only view migration through the lens of smuggling, then everyone is smuggled, or crucially, a smuggler. Now, I don't doubt for a moment that smuggling exists, of course. I've seen firsthand, rather, the consequence of this awful practice. But such a singular and reductive view is nonetheless problematic. And this is because it criminalizes migrants and those who help them. Securitization is no good for at least two reasons. It seems to facilitate the derogation of international obligations, laws, and values, but crucially, and I intend to dwell on this point longer, the policy is also self-defeating. Counter-smuggling policies prop up the business model of smugglers, with the massive collateral damage to migrants and humanitarians to boot. So you might be asking, who am I to be speaking about criminalization? Well, as Grainne said, I've spent about 3.5 months in pretrial detention as a consequence of what Human Rights Watch has referred to the criminalization of saving lives. And whilst that was now much more than 5 years ago, I'm still pushing for a trial that brings this matter to an end. And until it is brought to trial, and we are, I hope, acquitted, I still face 20 years imprisonment. And now you might be thinking, well, he must have done something wrong. What crimes did he commit? And it depends on whom you ask. The United Nations Office of the High Commissioner for Human Rights, Amnesty International, Human Rights Watch, many legal experts, some in that room, would say that I and my 23 fellow defendants are civilian search and rescuers and nothing more. The prosecution, on the other hand, says that I am a smuggler, a forger, an illegal listener of radio frequencies, which doesn't quite roll off the tongue as nicely, a money launderer, a member of a criminal organization, and my childhood dream come true, a spy. In truth, I did very little. I think we have an image of search and rescue as being this incredibly heroic undertaking, but that wasn't my experience. I mostly stood at a shoreline with a pair of binoculars and a first aid kit between the hours of midnight and 7 a.m. and just waited. The important thing to drive home here is that the vast majority of people don't interact with search and rescuers. People on the move are survivors. But even this small act should not be dismissed. I think in a Europe where we put up razor wire guard posts, sometimes even attack dogs, and strike deals with third countries that have a dubious human rights record, all in a bid just to stop anybody from being able to claim asylum in Europe, then simply offering a smile is important. So now you're thinking, okay, that's very depressing, but what has it got to do with me? Well, I think the really frightening thing is that if I can face 20 years in prison for doing almost nothing, and certainly nothing illegal, then you can too. I did research with an EU-funded project on the rate of prosecutions against humanitarians related to only one EU directive, the Facilitation Directive of 2002. And we found about 180 individuals in at least 13 EU member states who had faced prosecution. So this is clearly a bigger issue that affects all of us. And I would say that these prosecutions are underpinned by something larger still, a growing social attitude, at least as far as I have encountered it, that suggests that some people are more deserving of their human rights than others. The example I give is this. Imagine you arrive at the scene of a car accident and there's someone lying on the roadside and they need your help. What would you check first, their pulse or their passport? Well, if like me, you check their pulse first, you've committed the same crime that people often tell me that I have committed. To give a sense of flavor to this, I once got an email from a German-speaking pastor in Switzerland. He was being prosecuted because he let asylum seekers sleep on his church pews when the weather was bad. He was, of course, acquitted, as humanitarians are. Next slide, please. But if humanitarians are acquitted, that is, they are not actually smugglers, why are these cases even being brought? And I asked myself this question while in prison. It's when I came across this phrase, pull factors. I'm sure many of you are familiar with it. It is quite an intuitive argument that says the safer the water is, the more likely smugglers will be able to sell tickets for unsafe boat trips. And when I first came across this phrase, I was reading a Frontex risk analysis report from 2017. I suddenly realized why I was sitting on a prison chair, because I deserved to be there. I was effectively causing smuggling. But if you do only the slightest further research, as I did afterwards, you quickly realize that there is no evidence of a pull factor. Nothing. Weather patterns correlate with rates of crossings. The situation in the host country certainly does, but not rescue. Next slide, please. There is, of course, a safety factor, to put it roughly. You can see as the rates of crossings dramatically decline, the deadliness of the crossings increases. And I would say that as one of the wealthiest consequences, this is at least in part a decision that we've made. Question might then be, if not search and rescue, are there other European practices that might cause smuggling? Yes, and counter-smuggling policies appear to be one of them. There are a couple of facts, I think, that illustrate this point. If to be given protection, an asylum seeker must make it to the would-be host country, and if the would-be host country is in the EU, secure our border so that it is impossible to fly in or to walk across a border safely, then our securitization policies drive asylum seekers into the boats of smugglers. Next slide, please. Not only do these policies drive asylum seekers into the boats of smugglers, but they also conflate asylum seekers and smugglers. And I want to end on this point. The people who are actually found guilty of smuggling, spurious as the evidence against them often tends to be, it's asylum seekers. I mean, I shared a cell with people convicted of being boat captains, so-called boat captains, who say they were arrested simply because they happened to be using the outboard motor on their journey across that part of the water. As you'll be familiar, oftentimes what happens is that the smuggler jumps out of the water at some point, and suddenly these individuals are left stranded effectively, and someone takes the engine, does their best to aim for a light in the darkness that is hopefully going to be Greece or a European territory, and they'll aim for it. And having undertaken that journey, oftentimes they are arrested as boat captains. But I also shared a cell with a young Afghan man who spent 2 weeks in jail. Nobody told him why or for how long he would be there, because it seems he expressed frustration with the delays of his asylum claim. I think he was waiting over 2 years, and he protested, and he was thrown in to cool off, as it were, but no information given as to why exactly. I also met a German citizen of Yazidi background who came to the island to find his sister, whom he had hoped had made it across. They had lost contact during her journey over. And he was detained for nearly a month because the police doubted the legitimacy of his perfectly legitimate passport. And again, wasn't offered any semblance of fair procedures. Maybe worst of all, and perhaps others can speak to this being a wider issue, I met a Tunisian man who had been in a cell for over 3 months and may still be in there because, the Red Cross later told me, the authorities didn't know where else to put him. No charges, nothing. All these people never had the platform like the one I'm given right now, and they aren't even given lawyers. They're not even communicated with. And so the Greek model criminalizes people, and it criminalizes the most vulnerable most of all. That, I fear, is the direction that so many European states are heading in. I could perhaps, this ends the presentation, but speak very briefly about the status of my present case with the 2 minutes that I have left. And that is, as Grainne said, it has gone to appeal. So in January, we had our Court of Appeal, although first instance hearing about the misdemeanors, the espionage, the forgery, and the illegal use or listening to radio frequencies. And then the Court of Appeal judges and also the prosecution called for a dismissal of the indictment against us for a number of reasons. The two primary reasons is that it was too vague as to what exactly espionage meant. What espionage says in the law and what we were being accused of were not the same thing. And we felt, as the court did, that needed to be clearer. And secondly, we didn't have translations. For over 5 years, we have been saying that we need certain procedural aspects of the trial and the process adhered to, and they never were. And so the indictment was dismissed, and that ran against the statute of limitations period, which was 5 years and ended in February. Now it's gone to appeal, and we'll find out what the outcome is hopefully next month. But I want to just quickly finish on the limitations period. What we've noticed is that the prosecution doesn't seem to be that confident that we are guilty, because they seem to have been delaying this for as long as possible. And if that is the case, and it has an obvious outcome, it makes others afraid of volunteering on Lesvos. And indeed, today, there is no more formal civilian search and rescue organization in operation. And that is, I think, one of the primary outcomes of our prosecution. As a fun fact, the limitations period for the felonies, the 4 more serious charges, isn't 5 years, it is a further 15 years. And we fear that we might have to wait that long until we finally get our trial. That's time. Thank you very much.
Thank you very much, Seán, for that very powerful account of your own experience and placing it in the context as you have done of the Greek model, and quite shocking statistics that I hadn't seen quite like that before. 180 prosecutions across 13 EU member states. So a huge thank you to Seán, an opportunity for questions at the end. Please do save them or write them in the Q&A now if they're on your mind. But we're staying with Greece for our second speaker, and as I've said, we're hearing from Natasha, who works directly with migrants and asylum seekers in Lesvos and can speak to their experiences and also give an account of what Seán has touched on, which is the increasing criminalisation of those working with migrants and refugees, human rights defenders, search and rescues, boats, drivers, etc. So Natasha, over to you.
Hello, everyone. Thank you so much for this invitation. Again and again, hearing other people in the field talking about the experience is still very difficult to digest, although I'm part of this community. So I would like to say to Seán Binder before I start with my presentation that I completely agree. These kind of actions, even if they look small, they cannot be dismissed because they make us still feel look human in such dehumanizing conditions that are created and sustained at the borders. So I am a lawyer, as said, a Greek lawyer. I work with Legal Center Lesvos, is a civil non-profit organization operating on the island of Lesvos since 2016 and providing free legal aid to migrants that arrive on the island, and also engaging in broader solidarity work, advocacy, and strategic litigation in defense of migrant rights. So this continuous presence on the island of Lesvos made us witness all the implementation of a more and more violent, deterrent, and punitive policy against migrants who try to reach Europe by sea or by the land borders, and culminating in their criminalization, which was intensified as a parallel deterrence policy to the pushbacks. A turning point was the pandemic, when there were restrictions, movement restrictions for everyone. And so there was a climax in this direction of the specific adaptation of a modus operandi of pushbacks at sea. And it was easy to start to implement these policies much more, as there were no one to watch and to really be able to do something against it and provide humanitarian or legal support. So it happened in a completely untransparent way, causing fear to people that have suffered this kind of pushbacks. Still, we monitored them, and we were able, along also with other organizations, to provide reports about it and bring cases to the European Court of Human Rights. So today I will focus to just one aspect of these Greece's and EU's border policies, not on the pushbacks, but on the smuggling charges and what it means from a legal point of view, and what is this so-called anti-smuggling legislation. So ironically, one of the purported purposes of anti-smuggling legislation is to protect the rights of migrants subjected to smuggling operations, meaning not being themselves convicted for these actions. So we actually see the implementation of these laws is having the quite opposite effect. Anti-smuggling legislation, not only in Greece, but throughout Europe, is also contrary to the UN protocols on smuggling. The United Nations has defined smuggling of migrants as the facilitations of illegal entry to a state in order to obtain directly or indirectly a financial or other material benefit, and specifies that migrants subject to smuggling operations shall not be criminalized. Likewise, humanitarian assistance to migrants during illegalized border crossings is explicitly not subjected to criminalization. And also the original Schengen Agreement in 1985 contained similar language to the UN protocols, aiming to penalize those who assist in illegal border crossing for financial gain. In 2002, in the US facilitators package, this clause for financial gain was deleted, leading to a contradiction with the UN protocols. And going to Greece's current legislation, it is among the harshest in the EU. And in addition to no requirement of material or financial gain, and no exception for those that are themselves subject to a smuggling operation, Greece's anti-smuggling law carries a 10-year prison sentence and an additional 15 years imprisonment for each person transported whose life was put in danger. And the financial gain is only considered an aggravating factor, which does not make any significant change in the total sentence. Also, mitigating circumstances are technically to be considered in such trials, but in practice, in cases in which the legal center was involved, they were not taken into consideration. So we have an example of a trial in April in 2021, which accepted no mitigating circumstances for a young man from Syria, represented by lawyers with legal center Lesvos, who had been shot in Syria, arrested, tortured in Turkey, and then fled to Greece with his wife and 3 young children. And despite showing all these above circumstances, he was sentenced to 52 years in prison, and his wife has now, she was left alone for many, many years, and together with the 3 young children, wait for him. So we cannot really speak about a preparation of a smuggling operation being in such a condition personally. So while there is an exception also in Greek law for rescue at sea in accordance with the principles of international law, this exception has never been accepted as a defense in the cases the legal center has followed. Although in all cases, it has been migrants who themselves were subject to smuggling operations, who were then criminally charged. According to the Greek Ministry of Justice, in 2019, roughly 2,000 people were in prison in Greece on these smuggling charges, the second highest prison population in Greece, after those charged with drug-related offenses. Under current Greek criminal law, any person who drives a migrant boat is automatically considered to be a smuggler. It is such simple to be charged. So by large, and we know this as a fact, those who organize the crossing and who financially profit from them are not the people arrested and imprisoned, because it is common sense that the smugglers themselves, they are not making the dangerous sea crossing from Turkey to Greece. And in many, many occasions, they start driving the boat and then they leave the boat. And once they are a little bit off the shores of Turkey, they turn around with a smaller boat and leave the people without a captain, trying actually to rescue themselves. So the act of rescuing their own lives is considered a crime. Also, we must notice that Ireland, there was this anti-refugee sentiment growing and growing, and that led to organized attacks by far-right groups against migrants during these years, and those in solidarity with them, with the tacit support of local government officials and the police. So the court themselves, consciously or not, we don't know, but it happens, are effecting a form of collective punishment in this direction and deterrence in an attempt to stem the flow of refugees seeking asylum in Europe. This goes far beyond what the court is supposed to do. Most individuals accused of smuggling in Lesvos are arrested immediately upon arrival to Greece under the suspicion of having driven the boat, without sufficient or often any evidence at all. They are incarcerated for months in pre-trial detention, and when their case eventually goes to the trial, the conviction is determined in very short procedures. Sometimes they only last 15 minutes. To ultimately fail, and they ultimately fail core standards of fairness and due process. So what we have seen in this kind of trials in this kind of cases we have monitored include use of violence by the Coast Guard or the police during the arrest, arbitrary arrest, use of violence against defendants in pretrial detention and denial of medical and mental health care, lack of adequate translation during arrest, interrogation, and during the trial, conviction based on the sole testimony of the Hellenic Coast Guard, who most of the times is not able to really identify the specific person accused. He saw someone, or someone was other people in the boat being afraid of facing a collective punishment pointing to a person. Trials are often extremely short, as I said, and rushed. We have an example, people are convicted without evidence at all that the individuals committed this crime of facilitating illegal entry. So we had this it became quite famous, the trial of Akif Rassouli in September 2020, where we represented, in the beginning, he was appointed a state lawyer who just met him on the day of the trial. And he was convicted, he didn't know why he was convicted, and of facilitating illegal entry, despite the lack there was any testimony in the file, any witness stating that he was driving the boat. He spent 3 years in trial, and on the second instant court that happened in December, the last December 2022, he was actually acquitted of all charges and found not guilty. Yeah, a few things in relation to the also the criminalization of humanitarian aid and human rights defenders. So Greece, in relation to the anti-smuggling legislation, goes a step further than that provided for in the UE facilitators package, and making it a crime not only to facilitate illegal entry, but also to facilitate illegal stay, which is kind of absurd because there is no crime in the Greek criminal court, Greece criminal code that is called illegal stay. Still, facilitating illegal stay remains and contains no exception for those providing humanitarian assistance. So it can be applied at any time. And in this direction, there is a real situation. It's not only a threat of anti-smuggling law also applied against humanitarian actors and human rights defenders. And it is used as a political tool to deter migration through collective punishment, as I said before, of migrants who manage to arrive, and also in parallel to silence criticism and to create an environment of fear. This allows Greece to carry on its cruel and unlawful border policies that are not really that are agreed upon in the European Union policies. They are not doing something contradictory. Actually, they're implementing on behalf of the European Union these policies in the borders. So this is the situation, and if we want to reform this current anti-smuggling legislation, it is an important step, of course, to try to reform it, but it will be likely not sufficient because this legislation will continue to be used, and we have seen its application in Lesvos as a political tool to further the US and Greece's political agenda to deter migration. So it is necessary to look at both smuggling and anti-smuggling regulations in the broader context of EU migration and border policies, which create the need for smuggling's operations in the first place. I cannot say a closing word. I cannot close without referring to the deadly shipwreck of Pylos on the 14th of June in 2023, one of Europe's deadliest shipwrecks. If you ask people on the field, and people who provide humanitarian aid, they will say that this was expected. We saw it coming, because if you create these circumstances, this will happen sooner or later. So it should not come as a surprise. We are implementing these policies a long time now, and these are the results. And it's now many human lives were sacrificed, and it actually is the attention of the media was not only thrown there, but in the end to the 9 accused smugglers. So we are having this narrative that is put forward in the national and international press to blame actually the victims or the so-called smugglers for their death. But they are human lives, and we cannot forget it. And so we call again for an investigation on the circumstances and causes of this tragedy, and for due responsibility to be attributed both at the level of the Greek state and the EU, and to establish, we will say it again and again, safe and legal pathways for refugees and migrants to access EU territory. Thank you.
Thank you very much, Natasha. You encapsulated so much in that presentation. We're really grateful, in particular for that detailed analysis of how smuggling charges are being used in Greece. And many of you will have seen there have been numerous calls from legal experts, the UN, the EU, for Greece to bring its smuggling definition in line with international law. It is that glaring gap that Natasha has identified. But what she also says is there are problems in practice, and she's talked about the fair trial issues that can arise, in particular for some of the most vulnerable who these laws are used against: delays, lack of access to the courts, lack of any evidence. That's all a pattern that we're seeing in Seán's case as well. So a really excellent presentation, and I'm struck by and slightly horrified by that story of her Syrian client who got 52 years under the smuggling charges. So thank you very much, Natasha. We're going to turn to the UK now and think how, if at all, we can see any parallels with the Greek model that we've talked about, or what direction the UK may be travelling in. We're going to start with Georgie Ray, who is going to look at the criminalisation of small boats cross-channel crossings in the UK from a criminal and or public law perspective. So Georgie.
Thank you very much, Grainne, and thank you to Natasha and Seán. And I'm grateful to Natasha for that highlighting of the tragedy that happened in Greece on the 14th of July, which really kind of sets the tone for our analysis of this legislation, and particularly in the UK. So I'm going to be going through the legal framework of this criminalisation, which has evolved since the passing of the Nationality and Borders Act. But if we look at the history of it, we've got the Immigration Act in 1971, and there were 3 specific offences under this piece of legislation. First, we have Section 24, which criminalised knowingly entering the UK without leave, and that word entering, you'll see, becomes more significant as the case law developed. We then have Section 25, which criminalised assisting illegal entry, again, that enter, and Section 25A, which criminalised assisting asylum seekers. So that was the initial position. We then had some case law, which I'll be going through in a moment, which caused the legislative change under the Immigration and Asylum Act 1999. And here in Section 31, we find protection from prosecution under these offences. So what does Section 31 say? Well, it creates a defence for a refugee charged with an offence, so one of the ones I've just mentioned, to show that they've come to the UK directly from a country where their life or freedom was threatened, and there's a few preconditions they have to prove, that they've presented themselves to the authority without delay, that they showed good cause for illegal entry or presence, so that will be the basis of the asylum claim, and that they made their claim for asylum as soon as was reasonably practicable after arriving in the UK. There's a caveat to this, though, in subsection 2 of section 31, and that's if incoming from a country where life or freedom was threatened, if they stopped in another country, subsection 1 won't apply unless he could not have reasonably been expected to have sought protection under the Refugee Convention in that other country. So we do have this protection from prosecution, but there are criteria which must be fulfilled, and then it is unfortunately undermined by that provision in subsection 2. So there's also, prior to the passing of the Nationality and Borders Act, and probably what led to some of the amendments which I'll go through in more detail, the Home Office began using a kind of policy of prosecuting hand-on-tiller cases. So as Natasha said in her speech, this is where they identify whoever was in control of the boat at the moment of it being rescued or arriving, and deciding that that person is the one responsible. That person is the smuggler, which is of course not the case. Many of the smugglers leaving the boats before arrival, and the person who takes control of the boat actually just doing so in order to save everyone who's already on there. And sometimes this will be children or teenagers who are left to take the rudder, as it were. I believe that Jen's going to be going through this in more detail, but Article 31 of the Refugee Convention prevents contracting states from imposing penalties on refugees coming directly from a territory where their life or freedom was threatened. As long as they present themselves without delay and show good cause for their entry or presence. So the parts that we'll be looking at are that coming directly. So Article 31 prohibits penalising refugees for unlawful entry or presence if they came directly from the country where their life or freedom was threatened and show good cause for their entry. And this is intended to address the situation of refugees who are unable to secure necessary authorization to a country, that buzzword, the safe route. This exemption cannot be claimed by those who are already lawfully settled in another territory, so they're not coming directly from the country where their life or freedom was threatened. Any penalties must not undermine the right to seek and enjoy asylum, albeit variance with the provisions of the Convention. Moving on now then to the case law that saw the evolution of both the offences and the defence under section 31. The first case I'm going to be talking about is the Crown and Kakai in 2021. And the outcome of this case was a major blow to that Home Office strategy of prosecuting those hand-on-the-tiller cases, because they using those human smuggler offences, and it did this by creating a legal fiction of arriving in a country as being distinct from entering a country. So section 42 of the Immigration Act made it an offence if a person knowingly entered the United Kingdom in breach of a deportation order or without leave. And that didn't necessarily mean that a refugee arriving in the UK will have committed an offence. But then section 25A, that was the third of the 3 offences under the Immigration Act, that is drafted more broadly and does say the offence will apply where a person person knowingly and for gain facilitates the arrival or attempted arrival, or entry or attempted entry into the United Kingdom. But in the case of Kakai, he wasn't charged under Section 25A, so the court was able to construe Section 24 and this concept of entering as being different from merely arriving, where the line between arrival and entry is a legal fiction, but was useful for avoiding prosecution under that offence. So following the clarification, migrants who seek to arrive in the UK and claim asylum wouldn't commit an offence under Section 24. But the Nationality and Borders Act has sought to recriminalise that. Looking at the common law, abuse of process arguments, which were initially used to prevent prosecution, the first and foundational case regarding the Refugee Convention route was in the case of ex parte Adamini. It heard in 1999. And this case led to the introduction of defence, as we saw under Section 31 in the 1999 Act. The High Court in that case allowed judicial review of the CPS decision to prosecute under the Immigration Act and directed that the prosecution be discontinued. Now, the court held that although convention states have a duty to give sanctuary, they are not obliged to facilitate entry, and the combination of both visa requirements and carrier liability means that entry could only be gained sometimes by the use of false documents. So asylum seekers entitled to protection should not be prosecuted for offences connected with attempts to obtain refugee status, and the abuse of process argument should in those cases succeed. There's a legitimate expectation that the convention would be followed and accepted. So following the introduction of the defence under Section 31 and this case law, we have the case of Asfor in 2008. So this plugged at least some of the gaps that were left by Section 31 by deciding that prosecution which contravened Article 31 of the Refugee Convention would be an abuse of process and charges could be dismissed on this basis. The House of Lords observed that it was permissible to charge a defendant both with an offence to which Section 31 of the Section 31 defence applied. So that's the Section 24, Section 25 and Section 25A. But the prosecution could also bring alternative offences so that the defendant wouldn't have recourse to the Section 31 defence. But it would be an abuse of process if the prosecution brought those alternative charges merely as a way to undermine the accessibility of the defence to the defendant. So that's where we saw the law in 2008. There was also some clarification on the meaning of coming directly, and the three benchmarks of coming directly. We would look at the length of stay in the intermediate country, so were they just passing through or had they settled there? Any reason for the delay in arriving in the UK, and whether or not they sought and found protection in that other jurisdiction. So what do we have now? Well, we have the Nationality and Borders Act. So the Section 24 now reads, a person who requires entry clearance under the immigration rules and knowingly arrives in the United Kingdom without a valid entry clearance commits an offence. Section 25 remains the same as before, and Section 25A is modified to remove the full gain requirement. So it is much easier to prosecute the hand on the tiller individuals because they don't need to have been paid by anyone else on the boat. Merely taking charge can mean they're prosecuted under Section 25A. The Nationality and Borders Act also created a new Section 25BA to provide a defence, and that's to the Coast Guard or the RNLI, providing assistance to a person in distress at sea, which is one positive distinction from the unfortunate situation in Greece that has found Seán in his circumstances. The Nationality and Borders Act also increased the maximum sentence. So it was decided that 4 years would suffice for offences under Section 24, and now you can receive life imprisonment for offences under Section 25. So this has added that domestic spin to the coming directly element of the Refugee Convention. You can find that in Section 37 of the Nationality and Borders Act. And the wording is there on the slide, which I can't see because of the screen, but that's fine. So if you stopped in another country outside the United Kingdom, and you can show that they could not be reasonably expected to have sought protection under the Refugee Convention. So anything less than that will not be coming directly. Jen's going to be talking about this case, so I'll move on from it. But it was the first appeal of its kind under the Nationality and Borders Act. So hopefully we'll be going into that in a lot more detail. The CPS accepts, thankfully, that they can't prosecute everyone and it wouldn't be in the public interest to do so. And they have said that they will only be bringing prosecutions in cases where there are aggravating factors. So that's those who have re-entered the United Kingdom following deportation, or where there is evidence that they are actually the captain or pilot of the vessel. But research from the border criminologies at the University of Oxford shows that it's likely that over 185 people have been charged under Section 24 and Section 25. The problem is that there is no official sentencing guidelines, and even with that increase in maximum sentences, it's unclear to what extent mitigation will be taken into account and what the bans are for sentencing. We've seen chipping away at the potential defence by the redefinition of coming directly, and many people charged under these offences are being advised to plead guilty early for full credit, but of course that leaves them without a defence, and bail is routinely denied despite the presumption in favour of bail. So is it compatible with the Refugee Convention? As I said, Jen's going to be looking in more detail at R. Mohammed, but the UNHCR position is that refugees who leave a country in contravention of exit rules and present themselves without authorization may be protected under Article 31, particularly where they are transiting en route somewhere else. And that definition of coming directly under the Nationality and Borders Act seems to be inconsistent with Article 31(1) of the Convention, unless it continues to be interpreted with the case law of Adamini and Kakai. So with that, I'm going to pass back to Grainne, who will then pass to Jen, I think. And thank you so much, everyone, for coming, and I'll see you all.
Thank you very much, Georgie. So that is the first of our two presentations on the UK framework, and that's a really helpful introduction to the statutory framework, some of the case law, the offences and the defences, as Georgie said, and in particular to the Nationality and Borders Act. And we're now going to hear from Jennifer Twite, as I've said, who was involved in the most recent Court of Appeal case under the legislation that Georgie has been speaking about, that concluded that refugees could be prosecuted for simply arriving in the UK, even in the absence of any safe and legal routes. So over to you, Jen.
Thank you, Grainne, and thanks, Georgie, for the overview of the law. I should say I was led by Seán in that case of Rwanda fame and fortune. Sadly, the Court of Appeal were much less kind to us when we were in front of them in the Oldwell case. You've heard quite a bit of the overview of what's happening in the UK from Georgie. I'm not going to repeat what she says. I want to look in a bit more detail about Section 24, in particular prosecutions, because that's what we're really seeing is people being prosecuted simply for arriving. And look a bit about what the Oldwell case actually does do and anything positive we can glean from it. I've been instructing a couple of cases to do with these matters now, and I need to confess at the outset that I am not an immigration barrister. Please don't ask me questions about immigration law. I do criminal and public law, and so I'm really going to try and look at this from a criminal framework, and hopefully, if perhaps over a glass of wine, I now know I'm probably the only thing standing between you and a glass of wine, happy to answer any questions about the criminalisation and that aspect of these cases. So what I want to do quickly is look a little bit about exactly Section 24 and what the offence is and the law now says in light of the ruling. Although that doesn't take very long, the answer is everyone's guilty. Look a bit about what's happening in practice in terms of who's being prosecuted, the sentences they're receiving, whether or not that's compatible with the Refugee Convention and what we could do about it, because I imagine a lot of people can answer that question quite quickly too, and what avenues really are left open to people who are being prosecuted for these offences. So Georgie's explained to you already, and a lot of you probably know, that on the 28th of June last year, we the Nationality and Borders Act Section 40 came into force, which amended Section 24 of the Immigration Act and Section 25 about assisting unlawful migration to get around, quite clearly, to get around the judgment in Kakai, and to make sure that those people who are arriving are all guilty. It has been a criminal offence for a while to enter this country without the correct entry visa, but of course Kakai found that if your intention was to arrive at a port and just declare that you were a refugee and throw yourself on the mercy of the Home Office, then you weren't guilty of this offence. And of course, when they changed Section 24, they also had to change Section 25, the facilitation offence, because again, what was found in Banny was that if you were facilitating people again who were just going to come in and declare themselves, that you weren't guilty of facilitating illegal entry. And so that was clearly the intention. It was very clear in Parliament, that's what they were trying to do. I've put on the slides that you've probably already seen the new offences, and I put in bold what's changed in Section 25 in particular, which was to add the words arriving, and Georgie explained how that was now important. Section 24 D1 is a whole new offence, saying that a person who requires entry clearance under the immigration rules and knowingly arrives in the United Kingdom commits an offence. If there was any doubt that these offences did criminalise all those coming in small boats, that doubt was quite clearly quashed in the case of Mohammed and Oldwell. So what happened was that some of the first cases that were prosecuted under this new offence were listed in December of last year in front of Mr. Justice Kavanagh in Canterbury Crown Court for a preliminary hearing, in order for everyone to try and think of different ways of interpreting this, to try and give some defence to something for somebody. I'm not going to rehearse the arguments that were put forward because they all lost, and so they don't help us very much. But essentially, the court, but having the ruling, I am going to go back to and look at, because I say there are some helpful bits of it, and I put a link to it on the slides, because the ruling itself in December actually says a lot more helpful stuff than the Court of Appeal does in the later judgment. So it is worth going and looking at Mr. Justice Kavanagh's ruling itself. And essentially, it said, you know, if you arrive means you're simply coming to landfall. If you don't even get to the beach and you're intending to be rescued, you're still guilty because you're attempting to arrive. And so a lot of people are being prosecuted for attempted Section 24s. So in terms of statutory interpretation, I'm afraid that's probably the end of the matter. I'm going to turn then to what's actually happening in practice. And as Georgie's already said, and there's other research on this, very few people are actually being prosecuted as a percentage of who's arriving, which in some ways is quite good news, I suppose, although it doesn't create much certainty for those people arriving to know whether or not they fall into the category or not. And this is a paragraph from the judgment, and this is what we knew in December of last year. Of course, things will have changed since then, because the CPS came in the hearing to say this is what's happening, and actually gave quite a lot of evidence to the court about what they were doing in terms of who they were prosecuting. And at that time, they were prosecuting something like 3 to 4% of the people who actually arrive in small boats. That's still actually quite a lot of people. So when I say it's not that many people, it is still objectively a lot of people. And it's a lot more people than used to be prosecuted. So that's not meant to condone the practice, but there is still an awful lot more people who could be prosecuted if it all went wrong. And it does appear to be that it is the more what we call egregious cases that get prosecuted. It is the people they think have a hand on the tiller, or the people who have previously been deported. It doesn't appear to be children. Although I'm instructing, I don't have time to discuss it tonight, in a lot of age-disputed cases where that gets an awful lot more complicated, but those they accept to be children don't appear to be prosecuted. I'm also aware of a number of cases, but actually there's probably people who know much more about this than me, so please do if afterwards we'll have questions about it. But from what I'm aware of, I've seen a few cases where following representations the CPA's cases have been dropped, but also cases where reps have been made and they haven't been dropped. So it does appear to be that, as I say, a relatively small percentage is being prosecuted, and there seems to be some factors that decide whether or not you fall into the category of being prosecuted under Section 24. And what also appears to be happening is that in a lot of the cases, the hand on the tiller cases, people are being charged with Section 25 and Section 24, because obviously hand on the tiller means technically you're facilitating under that definition. A lot of people are pleading to Section 24s, having been also charged with a Section 25. And of course, the odd thing, which I'll come to a bit about these cases, is that whilst they are often prosecuting people who have their hand on the tiller, you don't have to have your hand on the tiller to be guilty of a Section 24. So even if you dispute that you had your hand on the tiller, or you think the evidence for that is not very strong, once you're in the system, that doesn't give you an out. And therefore, a lot of the people then, even though they might dispute that reason which has led them to be in that 3%, then end up pleading guilty to the Section 24 because they have no defence to that. Most of these cases are coming before a judge in Canterbury. The resident judge in Canterbury Court is on Judge James. He published his sentencing remarks, which are available online, in one of the first cases that pleaded guilty in front of him on the 28th of September. And I've just put a couple of the bullet points from those sentencing remarks up on the screen. These aren't binding, this isn't a binding authority. What he said was, this is one of the first cases to come before me. This is how I'm going to approach the sentencing. I'm going to publish my sentencing remarks to assist other judges so there's a consistent approach. So this attitude is being followed, from what I understand, in Canterbury, in the magistrates' courts on the Kent coast. As far as I know, it hasn't been appealed to the Court of Appeal. So it's not, as I say, it's not binding authority in any way, but it is the attitude that most of the courts are taking. And I say it's a publicly available document. What he says, and I say you can read the whole thing, but essentially he talks a bit about how the public are really concerned about channel crossings. He talks a bit about the fact that the maximum sentence has increased and therefore uses that as a justification to increase the sort of sentences he will give for these offences compared to what used to be given under the old legislation. He references the fact that lots of these defendants will have personal mitigation, i.e. be seeking asylum. And the reason that's slightly problematic is it makes it more difficult for you to say, well, my defendant is different because they're seeking asylum, because he's sort of saying, well, they've all got good personal mitigation, and that doesn't change the starting point. He says that essentially after trial, this is for Section 24, Section 25 will be higher. For Section 24, they should usually expect 12 months after trial. and usually a sentence of immediate custody. I'm not entirely sure why he thinks it's a sentence of immediate custody, because there's an awful lot of sentencing practice in criminal courts that says anything up to 2 years can be suspended. These are often people of good character, with personal mitigation, unlikely to reoffend, but there's the sentencing marks. He also says, and this is a little bit confusing, I think, and I don't think this is what's happening now, is if they plead guilty, that will be substantial mitigation. And obviously, early guilty plea is a third off, so you'd expect 8 months, so you're taking a 12-month starting point. And they will usually stay in the magistrate's court. Now, I put in brackets, that's my comment, is this still true? Because in September 2022, the magistrates had powers to sentence up to 12 months. And that's been reduced this year back down to 6. So I'm pretty sure when he said that, the magistrates could give an 8-month sentence, but now they can't. And my understanding is that most of the magistrates' courts are now committing all these for sentence to the Crown Court because 8 months obviously is out with their jurisdiction, which is interesting because I'm sure that his other Judge Daines had better things to do than sentence all of this, and there's an awful lot of pragmatic sentencing that goes on in criminal courts, and I imagine he's probably ruining the day that he's made all these come to the Crown Court just so they can get an extra couple of weeks in prison. But that's what's happening on the ground. Query again whether someone will appeal this at some point, and whether or not this will be upheld as the correct sentencing approach or not. As I say, it's very much not binding, but very much being followed at the moment. Moving on to my third question is compatibility with the Refugee Convention. Now, I don't want to repeat what Georgie said, and she's already gone through Article 31. A lot of you will be familiar with that. I've put it up on the slide so that you have it there. Obviously, there's an argument that if you make it illegal for anyone to arrive in a boat in this country, that may in itself be a breach of Article 31 of the Refugee Convention. What's more problematic is what we do about that. So Georgie explained how Section 31 works, and there's in itself issues with that in terms of whether or not it always provides a defence. It's important to note that the Secretary of State could add Section 24 and Section 25 to the offences that Section 31 would provide a defence to. But Section 31 is not a defence to Section 24 or Section 25 because it's not listed in Section 31(3). So again, you have no defence under Section 31. Section 31, as Georgie pointed out, was implemented after the case of Ademi, where the court said the UK is in breach of its obligations under the Refugee Convention. And in order to make the UK compliant, Section 31 was introduced. But now new offences have been created and Section 31 doesn't apply to them. So again, arguably, one might argue, this is all incompatible with the Refugee Convention. The problem with that, of course, is you can't argue that's a standalone argument in court. You can't say to the court, well, we're in breach of the Refugee Convention and therefore we're not guilty because it's not incorporated. What obviously happened in the Mohammed case is we said, this is a breach of the Refugee Convention, and that is a reason to interpret Section 24 in the way that we're suggesting it's be interpreted. But of course, we lost. But interesting what the court did about that. But the way Kavanagh dealt with that is he said, no, this is compatible with the Refugee Convention. And he used exactly the same argument that was used in Parliament. I haven't put hands up on the screen if any of you followed the arguments in Parliament. What they said in Parliament was it's fine to make it illegal for everybody. We just won't prosecute everyone. Right? And therefore, it's compatible. And Kavanagh bought this totally, and I won't read it out, but you've got the quote there in the judgment. He says, because there's prosecutorial discretion, and of course, because it is being exercised, only 3 or 4% are being prosecuted, we're not breaching the convention because we're not actually prosecuting it. The Court of Appeal just didn't deal with it. I put a quote from the Court of Appeal judgment. I'm slightly not entirely sure why, because this is when they sort of talk about asylum seekers, but it's more to demonstrate the fact that the Court of Appeal just didn't deal with whether or not it breached the Refugee Convention. It didn't say it did or it didn't, it just didn't really mention it. So that's where we are with compatibility with the Refugee Convention in terms of how the courts have dealt with it thus far. I've done one very bare slide about the relevance of the Human Rights Act. Oh, is that up? No. Sorry, I've gone through too much. The one point I want to make about this is this has yet to be litigated. in the case of Ardwell, we could not litigate whether or not the legislation was compatible with the Human Rights Act, because of course you can bring that as a standalone argument to the courts in the way you can't the Refugee Convention. Why couldn't we? Again, it's in paragraph 13 of the judgment. The Crown Court's noted jurisdiction to make a declaration of incompatibility. And even though the Court of Appeal does, because we were there against a preliminary argument, we could not raise anything that hadn't been raised in the Crown Court. So again, food for thought for another day. And again, of course, compatibility with the Refugee Convention may well be relevant to whether or not it's compatible with the Human Rights Act. I mean, not that it's the same test, but there may be further litigation to happen in that way. So finally, and I know I've got very little time, so I promise I won't be much longer. The one thing we have left is prosecutorial discretion. Pity I can't actually say it. And there is quite a lot about this in the judgment of Kavanagh. He says that even though, because he uses it as a way of saying it's compatible with the Refugee Convention. So he talks a lot about how, of course, it is inappropriate for the CPS to institute procedures against someone for whom it would be a breach of Article 31 to prosecute. And so he says that in the judgment. He actually quotes the whole of the CPS policy in the judgment, which is much longer than this, and again available online, but he points out that where there's no statutory defence, prosecutors need to have regard to the circumstances when considering the public interest at stage of prosecution. So it becomes in some ways even more important for the CPS to consider the public interest stage of prosecution, because this is the only route of compliance with the Refugee Convention. And anyone who knows any criminal law will know that every prosecution has to go through the public interest test, but this is a particularly unusual case, right? Because most of the time, if you shoplift, most of the time it is in the public interest to prosecute you, and we don't prosecute 3% of shoplifters. In this case, we're hugely reliant on the CPS, the public interest test, for compliance with an international convention. And that causes all sorts of problems that Grainne is going to tell me off if I tell you all of them, but it turns the CPS into a fact-finding body, right? Because whether or not you have your hand on the tiller is a massive factor as to whether or not you should be prosecuted. But normally you would have a jury decide, and who would have Turnbull directions if there's an identification issue. But instead you've got a CPS prosecutor who you don't get to have proper arguments with, who you can only challenge essentially on public law grounds if they get it wrong. So there's huge issues that I don't think have been thought through in terms of whether or not this is a sensible way of dealing with compatibility with the Refugee Convention. And that leads me to my final slide, which again is what Georgie said already. We've had the case of Ademi and Asfor that you heard about, that for a while now it's been said that it could be an abusive process to prosecute a case where it's not in the public interest to prosecute. And again, it's mentioned in the Kavanagh judgment. He says further that backstop, if the CPS do make the wrong decision, you can come back and run abusive process argument. And actually, abusive process has moved on quite a lot from Asfor and Ademi. The main case that I've put on the slides is AAD, which is not about small boats at all, it's about victims of trafficking. But it is the Court of Appeal judgment that says where it is not in the public interest to prosecute, that is an abusive process. And that is something that the court can kick out. And it's got an awful long judgment about it from paragraph 120 onwards. It's summarised at paragraph 142 of that judgment. And it does importantly talk about that jurisdiction, which I would argue is particularly important in a case where there's no defence, because that puts so much more pressure on that than being correct. And what AAD says is the test in the criminal courts where it's an abusive process is basically public law principles. Now, again, I'm not sure how thought through this is. I'm not sure how much I would want to go into the magistrates' court and argue on public law principles that the CPS decision to prosecute is wrong, because I don't think that, with all due respect to the magistrates' court, that necessarily the best place to litigate it. It doesn't rule out judicial review, which is my last half of the slide. Again, judicial review is mentioned specifically in the Cabinet judgment at 123. It's mentioned in AAD where it says you can only really use it in exceptional circumstances. The reason it says in exceptional circumstances, it's a you would normally bring it as an abusive process, right? So if you're going to JR, the prosecution, I haven't put the case law for JR and prosecution up here, but it is a decision to prosecute is amenable to judicial review. But you've got to read this case if you're thinking about doing it, because the courts are basically saying it should be an abusive process, and essentially you're going to run into alternative remedy arguments. But the point is, this is the only challenge people have at the moment. And on a case-by-case basis, rather than I think saying the whole thing is unlawful, to say for me, in my case, I'm a refugee, it's a breach of Article 31 to prosecute me, either it's an abusive process or it's a judicial review. And I just shoved in Section 6 of the Human Rights Act, because I'm sure you all know it. But of course, if you're going to bring any of these cases, the CPS are bound by Section 6 of the Human Rights Act to act in a way that's compatible with the Human Rights Act as well. So that might be another route to put in. So I feel like there is more litigation to happen that hopefully will be more successful. So I hope I've ended on a slightly more positive note, despite the fact it's all a little bit depressing at the moment. Thank you very much.
Thank you, Jen, and thank you for identifying those options to challenge a prosecution. What I noted when you were going through it was that the starting point for the sentence is 12 months after trial.
Oh, yes.
So all of our clients obviously will be really concerned about the risk of automatic deportation and will probably want to plead guilty. So that is the challenge, isn't it, in trying to get some of these more interesting arguments.
And I think that's why a lot of them haven't happened. Like a lot of the cases I know people have been, there are issues with bail as well. And often the quickest way out is just to plead guilty.
That is us finished in terms of our really wonderful speakers tonight. We've talked about wine a lot and we are technically at the end, but I would love to hear if you have any questions. We do have time for a couple, in particular, if you have any clients who are going through prosecutions or any direct experience of Greece, I would love to hear from you with any questions or observations. If there is a resounding silence, I will acquiesce and let us go for wine. But does anyone have any questions that they would like to ask either of our UK speakers or Seán or Natasha, who is still with us on the link? At the back, yes, hi.
For anyone who's practicing here, I'm just curious, knowledge in the room on how, if anyone's papped the CPS, sent pre-action protocol letters, if decisions to prosecute have been withdrawn on that basis. Curious for frequency, what hasn't.
Good question. I think Jen mentioned that reps can certainly be effective.
Yeah, I've seen reps effective in I think a couple of cases. I don't think we've gone as far as PAP, we've just gone as far as reps. But also in Mr. Aldwell's case, actually, the one that when we tried reps on that and he's just been sentenced, so that didn't work. And I'm not sure our reps were that far off of PAP. They look very PAP-like, but yeah. And in my experience generally is that the CPS, I've papped the CPS a few times, is that if you've got a good case, they tend to cave.
And I think it's about that crossover expertise between criminal and immigration solicitors and lawyers in particular, given the overlap. And I think when particularly if you have expert reports and things from immigration or early asylum claims, they can be really, really useful in giving to the CPS, just in terms of all of the personal mitigating factors that Jen outlined. Does anybody in the room want to say anything about any involvement with CPS, or are most people concentrated on the Home Office? Yes, another question.
Just wanted to add to the what Jen was saying about Section 24. So I wrote the Border Crim piece and have been in courts for the last 6 months and Folkestone Magistrate and Canterbury Crown Court with other people in this room. And I just wanted to add that Section 25 yesterday was the first ruling by Judge James on one of the cases, which was in Arup versus Mohammed. And he was given 36 months and Judge James said the starting point was 4 years. Because I think that's like only happened yesterday. So
Thank you. Yeah, that's good.
Thank you very much. Would anybody else like to say anything or ask anything before we wrap up? Yes.
I want to ask on that slide on the European Court of Human Rights, if the Crown Court doesn't have jurisdiction to make a declaration of incompatibility, are there any other ways?
That's a question for you, Jen. It would be judicial review.
Yes, there's a number of ways of doing it. I think if you challenge, as I was saying, I think in Ademi, they made it was part of the reason. No, that was it was an abusive process because it was a breach of the Refugee Convention. But the Court of Appeal has jurisdiction. The only reason the Court of Appeal didn't in our case have jurisdiction was because we took it as a preliminary hearing point, and therefore the Court of Appeal has a narrower jurisdiction. It can only hear stuff that could be litigation in the Crown Court. But you could take it as a normal appeal point against a conviction. You could take it in a judicial review, query how relevant it is in an abusive process argument, because you're going to get back to the same jurisdictional issue in the Crown Court. But if you then, let's say, case stated the judicial review, so there's different ways it could be litigated. So it's definitely relevant at some point.
Anybody else? The final question of the night. Yes.
It's not really a question so much as like, I was wondering, so I'm in a public law team. I've been looking into wanting to challenge these CPS decisions, but the biggest barrier I've really been facing is the speed at which people are going to the magistrates and being advised to plead guilty within a couple of weeks before anyone even seems to know that legal advice is available. And also the kind of duty criminal solicitors also just don't seem to be aware of any of this at all, kind of systematically. And I guess if there's any linking up or advice that you
Vicky, she's nodding at you.
I can just add that we're organizing like online seminars which link that you came to one of them already, that link the criminal practitioners who are based in Kent with immigration and other like public law practitioners like Jen as well has also attended. So if anyone else in the room is interested to join these kind of conversations, it's online, and the next one is going to be July, Tuesday.
It's a massive challenge for criminal solicitors because they're paid very little money. Things happen very quickly. There's a massive incentive to the people involved to get out of prison quickly by pleading. And also, like I talk about writing reps, the solicitors get paid a flat fee, and it's not normal part of a criminal process to write reps, right? It happens with really good criminal solicitors, but this is not standard practice. So like it's a rubbish situation when you're like, oh yeah, everyone's gonna write reps and pap, and like this is not what criminal solicitors do, right? So it's kind of fantasy land to say that this is how it works. So yeah, there's not an easy solution. And you're sorry.
Right now they're all going to the Crown Court.
Yeah, no, it's all going to the Crown Court.
Yes. There were a few more hands up at the back. Yes.
Yeah, if anyone's looking to do casework or in both crime and immigration, I do both. I'm a solicitor at ITN. That is financially feasible for firms. So if anyone's looking to pitch their training to their firms or is looking to train at firms to do both areas, there should be more practitioners doing both. And teams speaking to each other. So thank you for organizing something.
I think the details of the event that somebody mentioned, we can circulate that to our online attendees as well, because we all agree that there has to be more joint up working in the area. So we're happy to share any of that information. Okay, well, thank you all so much for joining us tonight and for your contribution. Thank you also to our everyone who's joined online. I hope you will agree, really fascinating discussion traversing Greece and the UK, and inspiring that we have some action points already following the discussion. And I think Sonali's introduction and reminder of everything that's been achieved in Rwanda shows us that we can make some progress, make some change, even if it takes a lot of heartache along the way. So thank you all very much for joining us. You're welcome to come. That's right. You're welcome to come downstairs to the hub for food and drink if you're able to join and to further discuss and exchange the information we've spoken about. This was the last in our Refugee Week series, but you can watch some of the other events, which I really recommend, on YouTube, and any questions we can help direct you to where that is. We probably will have an event coming up next month on Rwanda. If you have a particular interest in that, please make sure that you're signed up. And if you are online, there will be a feedback form which will pop up, and please do fill that in if you're welcome. But please join with me in saying a big thank you to our speakers, including Natasha and Seán online.
Thank you so much. Bye.